Your Honor, Mr. Boris was arrested for being outside of the home and was on a house arrest with GPS tether. His cousin died and they were doing a balloon release in the complex. Despite him saying, I'm not allowed to leave, she was like, get dressed, get out, repeatedly. You're in my house, you follow my rules. Phoenix Saxon for Phoenix Born. He's still turning for the court.
Phoenix Born. All right, you're asking for an adjournment.
I am, Your Honor. I have a bond argument.
All right.
Your Honor.
I will adjourn the matter April 6th, 2026, 9 a.m.
Also,
Bond.
April
16th at bond.
Your Honor, Mr. Boris was arrested for being outside of the home and was on a house arrest with GPS tether. The reason he was outside the home, he was still in the same complex. And this was relayed to me by his mother. She forced him to leave because he lives in her house, has to follow her rules. His cousin died and they were doing a balloon release in the complex. And she, despite him saying, I'm not allowed to leave, she was like, get dressed, get out, and let's go, repeatedly. You're in my house, you follow my rules. And he did it. As the map shows from non-compliance or GP, he sincerely was, he really was not far from his apartment. And that is the reason he was not hanging out. And given the time shown from departure to return, line up with the fact that it was a few minutes, the balloon release, and then he came back home. He did not go anywhere else, and he was on foot. So this is his first offense. He's 18 years old. He is a student. His mother also confirmed for me he is still in school. I'm waiting for a letter from the school showing that upon completion of this one exam, he will be finished as a senior and he will be able to graduate. So I'm asking for his bond to be modified to a personal bond with him remaining on the GPS tether. And now his mother has full understanding of what house arrest means.
How come he didn't respond?
I'm sorry, Your Honor?
Respond when alerted. Why didn't he respond when alerted that he was in the zone? I mean, they send warnings and notifications and attempt to try to contact him. There was no contact.
Again, it was, you're going to be here. We're doing this release, period. It sounds cliche. I'm not being sarcastic at all. He was caught serving two masters at this time, the law and his mother.
The response from the people.
I would leave this up to the discretion of the court. Certainly, I haven't been able to have contact with the father or confirm whether or not he actually does come out. I trust counsel at her word, and if she spoke with the mother, I trust her on that. Those representations made to the court. I'll leave it to the court.
I do have the text messages from the mother that I'm willing to show prosecutor in the court. But for transportation issues, she would have been here this morning.
And looking over the report, I guess he was out maybe 10 minutes, but given that explanation, I'll grant the motion for a bond modification. His previous bond conditions, including the bond, is restored.
This is a useful example of why a bond violation does not automatically produce the harshest possible response. The defense gives Judge Simpson a very specific explanation. This 18-year-old allegedly remained inside the same apartment complex, attended a brief family balloon release after pressure from his mother, and returned shortly afterward. More importantly, counsel offers corroboration through the GPS map, timing, and text messages from the mother. That is far stronger than simply asking the court to accept the defendant's excuse. But notice the issue Judge Simpson immediately identifies. The defendant apparently did not respond to tether alerts or attempted contact. That matters because electronic monitoring only works if the defendant complies with its communication requirements. The defense's serving two masters argument humanizes him but legally, his mother's instructions cannot override a court order. So why grant the modification? The transcript suggests the judge sees this as a limited, explainable violation rather than evidence that the defendant was fleeing or deliberately abandoning supervision. Would you have accepted that explanation, or does ignoring the tether warnings change the entire picture for you?
All right.
Here we did have one additional matter with the defendant's bond being restored. I know the court sessions for April 16th. I have your question, could you get just a little bit longer than that? I anticipate there being additional reports forthcoming, and I don't know how long it's going to take to get, because I just don't want to be in the back on 16th. We still don't have all the discovery orders.
Got it. Any objection to that, counsel?
No, Your Honor.
I'll go to the 30th,
Thank you, Your Honor.
2026-90. Can you, Tanisha Moore?
Your Honor, Raymond.
Good morning, Your Honor. William Amadeo, P76194 for Ms. Moore, who will be approaching. Tanisha, when you get up here, please state your name for the court.
You're requesting an adjournment.
Yes, Judge. I'm asking for a 2-week adjournment and to briefly be heard on bond. I was asked to take over the file last night. So I just want to
Cause conference April 6th.
As the bond, Judge, I'm asking for a PR bond with GPS Tether. I'm working on a plea right now, which will require restitution. She could get her job back if she is released from jail. She's been sitting for 12 days on the violation. On the bond, I should say, she couldn't afford.
Can you? Do I have a response from the people?
I have no objection to the GPS. I believe the reason for the bond being set the way it was because the defendant does have prior failures to appear on other cases. So there was a flight concern, but I feel that with a GPS tracking Tether that way.
How many prior failures to appear?
I believe that she actually has 2 misdemeanors in front of Your Honor. One township, one state case that she appeared over a year ago. I don't know if those are set for another trial or pre-trial date or arraignment date yet. I believe there's CCH also indicates that there was a failure to appear on, I want to say it was 33rd district, but I can double check that. But there's 3 failures a failure to appear on 3 different cases.
And Judge, I could briefly reply to that.
Go ahead.
The 33rd district, it looks like that case is not in play anymore. I did call them up. I do know there's been some issues, but I also know she's been sitting for 12 days. I just got this file. I intend to get everything wrapped up into one. She does need to pay the restitution. I also did a bond memo.
A drug issue involved in this?
Not that I'm aware of, Your Honor.
Or a substance abuse issue? Because the magistrate set the bond at the 10,000, 10%, and indicated consider release to treatment.
This is the turning point in the second bond argument, because Judge Simpson has identified something neither side appears prepared to explain. Defense counsel is emphasizing 12 days in custody, potential employment, restitution, and GPS monitoring. The prosecution is willing to accept GPS despite 3 reported failures to appear. But the judge spots a separate clue in the existing bond record. The magistrate specifically contemplated release to treatment. That creates an obvious unanswered question. Why would treatment have been mentioned if there were no substance abuse concerns before the court? Defense counsel candidly says he just received the file and knows of nothing in the court system. The prosecutor likewise cannot supply an answer. That honesty is better than guessing, but it leaves the factual record incomplete. Strategically, this matters because Judge Simpson now has 2 different risk questions. Will she return to court? And is there an underlying issue that requires structured treatment rather than simple release? GPS may address location and flight concerns, but it does not itself address substance abuse. Did you notice how one line from the magistrate's order changed the focus of this hearing? Would you release her before finding out why treatment was originally contemplated?
Does anybody have anything of a substance abuse history with this defendant?
I didn't say what you told us.
Nothing in the court system. Yeah, Judge, to my knowledge, there's nothing in the court system about drug use.
What?
Nothing in the system about drug use in the court system. I don't know what she's done in her personal life before I got involved, but I have no notes on that.
Well, somebody needs to check into that. There's a reason why the magistrate indicated that. I would sign an order for her release to treatment on a PR with a GPS tether, which is what's set. That may be appropriate in this case. Certainly, I'll address it again on the 16th. But at this point, that's all I'm going to do. So our bond will continue. I'll sign an order for release to treatment on a PR with a tether.
These two hearings show Judge Simpson taking a case-specific approach to bond, rather than treating every violation or detention request the same way. In the first matter, the defense supplied a narrow explanation for the house arrest violation and offered supporting information. The defendant remained near his residence, the timing allegedly matched the family balloon release, and counsel had messages from his mother. The judge still challenged the failure to respond to monitoring alerts, but ultimately restored the previous bond conditions after considering the explanation. The second defendant presented a more complicated record. Her lawyer argued that 12 days in custody were interfering with employment and the ability to make restitution, while GPS could provide supervision outside jail. The prosecution did not oppose GPS, but the reported failures to appear created a legitimate concern about whether she would reliably return to court. Then Judge Simpson noticed the unresolved treatment language from the magistrate's earlier bond decision. Instead of pretending that missing information did not matter, he required further investigation and kept the existing bond structure in place while authorizing release to treatment on a personal bond with GPS tether. That is the broader lesson here. Bond decisions are not simply punishment before trial. Judges are evaluating compliance, appearance risk, supervision options, and the reliability of the information presented to them. Which argument do you think carried more weight here? The defendant's personal circumstances or the safeguards offered by GPS and treatment? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.